My name is Cliff Kirsch, and we want to welcome you to the Eversheds Sutherland Webcast Advisors Act Regulatory Series, and this is our second quarter update. I'm joined today by my colleagues Michael Koffler, John Walsh, Issa Hanna, Ben Marzouk, and Bria Adams. And this program is the latest in our quarterly series of complimentary webcasts dedicated to issues affecting investment advisors. And again, thanks for tuning in. Before we begin, just a couple of quick housekeeping notes. Number one, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And also, if you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. And also, in terms of our slide deck, if you want a copy of that, please feel free to contact any one of us. Just shoot us an email, and we'd be happy to send that to you. We have a lot to cover, and we're going to focus on advisory, regulatory developments, exams, and other important trends. And our focus this quarter, obviously, with the SEC's rulemaking earlier in June, we're going to focus on the advisory interps in terms of the advisory fiduciary duty and the related broker-dealer exclusion. Then we want to spend time looking at the Robare ruling regarding made disclosures and willfulness. Then take a look at certain state regulatory initiatives. Look at a recent, very significant no-action letter for MMI, which that was issued to MMI that dealt with mutual fund prospectus delivery. And then we're going to discuss OCIE updates. So with that, the first issue we're going to look at is the SEC's rulemaking, and more particularly the interps with respect to the advisor fiduciary duty. So I'm going to hand that over to Issa Hanna to walk us through that.
Great. Thank you so much, Cliff, and thanks to everybody for joining us today. We're very thankful to have you. So just to jump into these two interpretive releases that came out as part of the larger package of rulemakings and interpretations that the SEC put out on June 5th. These two interpretive releases were adopted under the Advisors Act. The first is a release that discusses the standard of conduct for investment advisors, and the goal of that release was really to reaffirm and in some cases clarify certain aspects of the fiduciary duty that investment advisors owe to clients under Section 206 of the Investment Advisors Act. And in a moment, we're going to get to the second interpretive release that came out as part of this rulemaking package. That interpretive release, as Cliff just mentioned, gets to the issue of the interpretation of the solely incidental prong of the exclusion from the definition of investment advisor for those broker-dealers who provide advice in connection with securities transactions. So focusing now in particular on this standard of conduct for investment advisors interpretation, one point I wanted to make, which is an overarching point before we dig into the real nitty-gritty of it, is that this interpretive release, as well as a solely incidental interpretive release, is different from the Reg BI and the Form CS releases in one critical way. And the big difference is that these two interpretive releases are effective essentially now. The releases technically are effective when they're published in the Federal Register, and we're still waiting for that to happen, but that'll really be any day now. So one thing you have to consider about these two interpretive guidance releases is that they're effective now, and you should be reviewing them with a view to whether your current practices, policies and procedures, disclosures, investment management agreements, etc., line up with what the SEC is saying in these two releases. So that's an overarching point that I think you have to be cognizant of when you dig into these releases on the front end. So just digging into the interpretive release for the investment advisor fiduciary duty here, it differs in some aspects from the original proposed interpretation. the way that really differs is that it includes a discussion of the way in which the fiduciary duty applies depending on whether you're dealing with an institutional or a retail client. The proposed guidance did not get into that distinction, but this guidance does get into that distinction and provides certain examples of how the fiduciary duty plays out depending on what type of client you're dealing with. And I'll get into that more in the next slide. It's also important to note that although the release does indicate that there are certain circumstances in which full and fair disclosure would be enough to deal with a conflict of interest, the disclosure of a conflict alone does not relieve an investment advisor of its duty of care obligation. The duty of care obligation is a separate and distinct obligation to act in the client's best interest that cannot be disclosed away. The full and fair disclosure element really gets to the duty of loyalty. So that's an important thing to keep in mind as you're going through this release. The last point I wanted to make with respect to this slide is that, the SEC says that in certain cases, full and fair disclosure requires mitigation before you can get to the point where you are providing full and fair disclosure. And in particular, they said that sometimes a conflict is so complex or difficult to understand or so extreme that it's not really possible to provide disclosure that is sufficient for a client to provide their consent. So before you put together that disclosure, you have to mitigate the conflict in some way to make it more understandable or to make it less extreme. Unfortunately, the SEC did not accede to commenter requests to provide examples of the types of conflicts that would require such mitigation or what would constitute effective mitigation. But we think that it's fair to say that based on this interpretive guidance, going forward, the SEC is going to expect investment advisors, as part of their ongoing conflict management process, to consider whether each conflict that they're inventorying as part of that conflict management process is something that is being adequately disclosed, or if it's something that requires mitigation before the advisor can get a client consent to it. We think that it's fair to say that the SEC in future exams is going to be looking for some kind of consideration and a documentation of that consideration of whether each conflict rises to the level of a conflict that requires mitigation. The last thing, actually, before I move on to the next slide, one general point I also wanted to make. In footnote 8 of the interpretive guidance, the SEC addresses the possible proposals that they said that they would be considering as part of, that they kind of laid out in that proposed interpretive guidance. And you may not recall this, but in the proposed interpretive guidance from last year, the SEC said that they wanted comments on whether they should propose new rules governing licensing and continuing education requirements for investment advisor representatives, whether investment advisors should be required to hand out account statements, and whether investment advisors should be subject to financial responsibility rules that are similar to those that are already applicable to broker-dealers. In footnote 8 of the adopted guidance, the SEC said that they're still considering the comments that they received on those possible proposals, and they didn't really show their hand as to whether they're going to go forward with those, but that's something to continue to watch. So with respect to this next slide, the SEC slightly altered the investment advisory landscape in certain ways. So coming back to this difference in how the fiduciary duty plays out depending on whether your client is an institutional or retail investor, the SEC recognizes that institutional clients may assign an advisor some specific mandates rather than the management of an entire portfolio. For example, an institutional client might only ask an investment advisor to manage a fixed income mandate. Thus, in recognition of those limitations, the SEC says in the interpretive guidance that an investment advisor's duty of care would not necessarily obligate the advisor to keep abreast of the client's investment objectives beyond what's required in the mandate or the investment management agreement that governs it. Second, with respect to the duty of loyalty obligation, how that plays out in the retail versus institutional context, the SEC also says in the interpretive guidance that it recognizes that institutional clients may be more sophisticated or have more resources to understand complex or extreme conflicts. And in that situation, and as a result, an institutional client may be able to consent to those more complex conflict disclosures in a way that retail clients may not be able to. The second point here that we make with respect to the Heitman Capital Management No Action Letter, in a footnote in the release, the SEC basically rescinded that prior no action letter because it said that basically, based on the comments that it had received with respect to that no action letter, it believes that the industry was misinterpreting it. So the SEC basically restated its guidance with respect to hedge clauses and the manner in which they can be deployed. The upshot from that guidance and the rescinding of the Heitman Capital No Action Letter is that you should take a look at your existing client investment management agreements to see whether they now or they may not align with this new SEC guidance that the SEC is providing about hedge clauses. Final point on this is that the SEC clarified that the fiduciary duty or the anti-fraud obligations under Section 206 apply to advice about account types and advice about whether to roll over assets from one account to another. It's important to note the first prong of what I said. The anti-fraud obligations can apply to that type of recommendation. And the nuance there is what the SEC is saying in the interpretive guidance is that even if somebody has not necessarily become your client yet or hasn't actually signed an investment management agreement with you yet, you still owe a level of care to a recommendation to that client, for example, that they roll over their assets in an existing retirement plan over to your management. And basically what the SEC said is that the fiduciary duty doesn't necessarily attach in that prospective client relationship yet, but the anti-fraud obligations attach. And at that time, when you're making a recommendation for somebody to roll over assets or choose an investment advisory account, you have an obligation to ensure that that recommendation has a reasonable basis. So moving on to the solely incidental
and just
release.
I'm sorry, so just one thing, and Michael may have thoughts, or John, we've been talking a lot about a team, about something you just said. The duty of care has always been out there. The fact that an advisor owes a duty of care and a duty of loyalty. But I think, and you get to this, what the SEC is really doing is saying you as an advisor need to pay attention to that duty of care, and it's more than just disclosing conflicts, and that duty of care has been, maybe a way to say it's a little underdeveloped in terms of regulatory notices, exams. But one thing that might come about, or one thing that we could expect to see, is just much more focus by examiners, on the duty of care. How do your policies and procedures address it? How do your determinations address it? So I think that's so I'm glad you mentioned. I think it's a huge takeaway from this whole thing.
Yeah, I think the commission could have done, and I kind of expected them to go further on that front, but I think that's kind of one of the hidden takeaways from this is the focus needs to be not just on disclosing conflicts, but on process, prudent management, having prudent process, training, documentation of the advice that is provided. All too often during exams, when staff comes in, the process and documentation varies significantly from office to office, rep to rep, branch to branch, et cetera, et cetera. And I think there's just going to have to be more uniform process and documentation of investment decisions going forward. A couple of other things I just want to mention that follow up on what Issa said. With respect to Heitman, this is one of those releases where we're going to be talking about footnotes.
Yeah.
Which we shouldn't really be doing, but unfortunately we are. It should be brought out, not in a footnote. But, footnote 31 on Heitman and hedge clauses, the commission basically signals hedge clauses are per se impermissible for retail clients. They don't use those exact words, but that is certainly the strong implication. And they say for institutional clients, it's going to be a facts and circumstances analysis. You look to things, what is being waived, how broad is it, how sophisticated is the institutional client, are there other ways that the client can protect themselves, et cetera. So it's going to be facts and circumstances at that level, but at the retail level, it's basically not acceptable going forward. Number two, there's another footnote that has received some attention, which is footnote 57, relating to the famous and or debate that came up at the commission meeting and was discussed by the SEC investor advocate. There does seem to be a disconnect between some of the language in the release discussing advisors have an obligation to either avoid conflicts or disclose them. We've been living with instructions in ADV, the general instructions for Part 2A for some time that say, well, there's an obligation to do both. And I think one of the effective takeaways, even if it was not intended, is that, well, you really probably don't have to do both, at least going forward. And that was criticized by investor advocates, by some of the groups, fiduciary groups, et cetera. But it's interesting that we're going to have this disconnect between the ADV instructions and the form itself.
Thanks, Michael. So with that, moving on to the next interpretive release that came out as part of the rulemaking and interpretive guidance package. In this release, the SEC addressed its interpretation of the solely incidental prong of the broker-dealer exclusion from the definition of investment advisor that appears in Section 202 of the Advisors Act. So why did they do this? It seemingly kind of came out of nowhere. When the agenda was announced for the meeting, I think something that a lot of people picked up on is, where did this come from? Why are they doing this all of a sudden? And the SEC tries to address that in the release. They say that they received a number of comments on the Reg BI proposal, which did, fair enough, solicit comment on whether they should, come back to the solely incidental clause or the solely incidental prong. But they said that they received some comments in response to that ask, and what they realized is that there was substantial disagreement regarding the interpretation of this exclusion. So the SEC decided to take it upon itself to clarify and confirm its position with respect to the broker-dealer exclusion from the Advisors Act. To illustrate how the exclusion functions, they discussed in the interpretation its application to two specific advisory services that a broker-dealer might provide. The first being exercising investment discretion, and the second being account monitoring. And before they got into those particular examples of advisory services that a broker-dealer might provide, they made a key point, which is that the availability of this exclusion does not hinge on the quantum or importance of the advice provided. Rather, the key is that the sale of the product remains the overall primary goal of the transaction. So getting into the particular examples that the SEC discussed in the release, with respect to the temporary or limited discretion, or just the discussion of permissible discretionary activities, one thing that the SEC makes clear in the release is that unlimited discretion is not consistent with the solely incidental prong, or the broker-dealer exclusion in general. If you're a broker-dealer and you have unlimited discretion with respect to a customer account, that is not consistent, and you have to treat the account as an advisory account and make sure that you're registered as an investment advisor and the person dealing with the account is a properly licensed investment advisor representative as necessary to deal with that account. That's the first point. But the second point, which is less black and white, is that the SEC said that there are circumstances in which temporary or limited discretion in time, scope, or other manner lacks the comprehensive and continuous character that would suggest a primarily advisory relationship. And then the SEC kind of went into 7 particular examples of temporary or limited discretion that would be consistent with this broker-dealer exclusion. And I would direct you to page 17 of the interpretive guidance to take a look at those 7 particular examples. I won't run through all of them here. But as you take a look at those examples, it's probably a good idea to compare those against your existing policies and procedures to see whether they capture those particular examples as permissible discretionary activity in a brokerage account. The second example that the SEC delved into in this interpretive guidance related to an agreement to monitor. So basically what the SEC said is that if there's a specific or a voluntary agreement to monitor an account, in that situation, that might arise to the level of an advisory relationship, and it kind of just depends on the facts and circumstances. Then, if a broker-dealer does not specifically agree to undertake account monitoring and does not voluntarily undertake that monitoring, that is not the level of services that arises to the level of advisory services. The upshot from this, we think, is that broker-dealers should adopt policies and procedures that clearly delineate how any monitoring they provide differs from the monitoring that they might provide under an advisory relationship. And obviously that's only going to apply if they're a dual registrant or they have an affiliated advisor. And you're going to also want to, in those policies and procedures, prohibit the registered representative from collecting a separate fee for such monitoring. Because if you collect a separate fee for ongoing account monitoring, no matter what the nature of it is, that's not going to be within the broker-dealer exclusion because that's a separate fee for those services. And I think maybe Cliff and Michael might have a couple of additional comments on this.
Yeah, I just want to reiterate, Issa, what you said, that this release is going to go into effect any day now. So there are many ways that a dual registrant, for instance, can trip up on the exclusion right now. If you have registered reps who are associated persons of your broker-dealer but are not supervised persons of your advisor, and they have agreements with clients that give them a power of attorney or give them unlimited discretionary trading authority under the current NASD rule, then that's something you're going to have to fix right away. Given the limited time frame, we would expect the SEC staff to be reasonable and give firms a chance to really adjust to the interpretation. But, if you're a large dual registrant, you have, hundreds or thousands of reps with hundreds of thousands of client agreements, you really need to get on this ASAP and really make sure that you're not giving yourself authority, even if that authority is not really exercised. But if you have that authority, you are in danger of crossing that line and basically acting as as an unregistered advisor vis-a-vis that client. So you really need to start looking at your documentation as soon as possible.
Great. Yeah, so a lot more to come, and we'll return as there's other themes and points and issues that arise, in our quarterly updates. But we wanted to, pivot to another significant development that happened during the quarter. The U.S. Court of Appeals in the Robare ruling, and we're pleased to have our colleague John Walsh walk us through that material.
Thanks, Cliff. Yes, a very significant and interesting decision, and I think it will have a big impact on everyone once we figure out what it means. And right now, we're not fully there yet. The decision came down on April 30th. And it is captioned the Robare Group Limited versus SEC, and it reviewed a decision by the SEC that involved an advisor's disclosure of conflicts of interest arising from its receipt of payments from a custodian. And the court focused on 2 issues. Was there a disclosure violation there under 2062, and did the firm willfully admit information from filings under Section 207? Now, part of the reason why this is so significant is because most cases that the SEC brings, particularly in a regulatory context, are settled. And those settled cases have a great deal of importance to really anybody in the regulated community because they tell you what the SEC is thinking, what its view of conduct is, how it's going to analyze the conduct in light of its statutory mandates. But the reality is those settled cases have very little precedential effect. One can debate the extent of their precedential effect. There are some people who say it's a finding of the commission and therefore should be given a certain amount of credit. There are other people who say as a settlement it really doesn't mean anything beyond the parties. I think if you're in the regulated community, it's very important and you want to pay careful attention to them, whatever the legal effect of the decision. Well, every once in a while a case comes along where the parties decide to fight, and they go to litigation. And as a fully adjudicated decision at every level, that case is given much greater weight than a settled case, whether it's an ALJ decision, a commission decision, and certainly here even more, one that has reached the Court of Appeals. So in essence, this decision can sweep away and trump years of settled practice by the SEC. And it seems to have done that here. So let's go to the next slide if we could. So what did the court do? Well, first, it looked at Section 2062. Of course, that's an anti-fraud section. And it said, were the advisor's disclosures inadequate? And ultimately, the court concluded that the SEC had been right, and the firm's disclosures were, in the court's view, inadequate, and the advisor's conduct had been negligent. And I think the court pointed in particular to the fact that the disclosure failures had stretched over several years, and that it found this meaningful. And the advisor had brought in expert testimony that its disclosures, and quoting here, conform to or exceeded the industry standards. And the court said, you know, that's possibly relevant. We can look to that to determine whether someone behaved reasonably under the circumstances, but it's really not dispositive because to determine a negligence case, we look at a standard and we see if you met that standard, and whether a lot of other people meet that standard, yes or no, is not really relevant to determining whether you met it. And I think one of the immediate takeaways from this case is everyone always wants to know, how do we compare to our peers? And there's nothing wrong with that. That's a good benchmark. On the other hand, if you say, well, since we compare well to our peers, we must be okay, I think the Robare case makes it plain no, that does not necessarily follow. Well, the case, though, gets interesting when we turn to Section 207. And the SEC had found that the firm had willfully admitted material information from its disclosures. And and I don't want to get too deep into the weeds here, but it could be significant. The parties had agreed that a prior decision by the D.C. Circuit from the year 2000 called Walsh provided the proper standard. And the Robare court said, well, we're not going to decide this, but since the parties agree that's the right standard, we will apply it. And that decision had stated that willful means intentionally committing the act which constitutes the violation, and it had rejected the idea that you must have an awareness that you're violating a particular rule or a particular standard. And the SEC found that the firm had acted willfully because it had intended each of the acts. It intended to file them, it was responsible for the content, it intentionally chose the language, And up till this point, what the SEC found is a classic example of what many people call the sleepwalking standard. And that is, if you're not sleepwalking, if you volitionally intend the acts that constitute the violation, then you are willful. You don't have to have a subjective intent. And the SEC stated this, and frankly, back in my days in the Division of Enforcement, this would have been completely unobjectionable, of course. This was the sleepwalking standard. Well, the court disagreed. The court said that the SEC first was taking an inconsistent position by holding that the same conduct was negligent for purposes of one provision and willful for purposes of the other. Negligent for 2062 and willful for 207. Further, the court said 207 requires the SEC to find, based on substantial evidence, that at least one of the firm's principals subjectively intended to omit material information from the form's ADV. So as a result, the court upheld the SEC's findings under 2062 and rejected the findings under 207. Well, what does this mean? Let's go to the next slide, please. The short answer is no one really knows. And I think it's pretty clear that the SEC is uncertain as well. There are multiple reports of people in the Division of Enforcement asking for extensions to tolling agreements in open cases so they can try and figure out what it means. There are reports, which actually are probably better described as rumors, that they are thinking about, well, should this only be limited to advisors? And I think that's probably not a preferred solution. Cliff and Michael were talking about dual registrants a few minutes ago. Well, how does it work in a dual registered situation where willful means one thing for the advisor half of the person and another thing for the broker half of the person? So frankly, as they try and sort through this over at the SEC, I appreciate that they need time, and it seems like that's what they're trying to do. There are a couple of points we can make, though. One is, I think this may be the end of the sleepwalking standard. I think that willfulness, in light of this decision, is probably going to have more meaning than it did in the past. And any articulation of what willfulness means, such as we saw in the Robare decision, or even some other articulation that adds more content to it than not sleepwalking, is going to mean there will be more of a standard there than in the past. And willfulness as a standard is found throughout the Advisors Act and other the other regulatory provisions that the SEC administers as well. And so if, in fact, there is a higher standard, then that's going to have a very far-reaching consequence. What does that mean? Well, it's not clear. Will it be harder to settle cases? It might be. The SEC might have difficulty with people saying, I'll take negligence, but I'm not going to say that I subjectively intended to do this. And so it may have more difficulty getting people to agree to willfulness. We just don't know. Or they may start avoiding the provisions that require willful and focus instead on cease and desist orders and penalties, which do not have those requirements. Time will tell. Open issue. Let's turn very quickly, if I could, to two issues that the Court of Appeals did not touch on. May advisors rely on compliance consultants as a defense? In its decision, the SEC had said no. It had said there's no law supporting the proposition that reliance on a compliance consultant is tantamount to reliance on advice of counsel. I think a careful reading of the SEC decision, you can see it's really less important than one might think at first blush, because the SEC really takes it on at a factual level, saying we're not finding evidence of reliance here. So who knows? Perhaps a case will come down the road in the future that more squarely presents the issue, where the evidence supports that there was, in fact, reliance. The other issue that the Court of Appeals left open, and this is the one that has already had a huge impact across the business, is it inappropriate to use the word may when you're describing a practice? In its decision, the SEC said that the firm here said it may receive compensation from the custodian, which may create a conflict at a point in time where it had already entered into an agreement to receive that compensation. Well, I think advisors all around the country immediately began doing global searches of all of their disclosure, looking for everywhere the word may appeared, and asking themselves, is may the right word here? If you do that often enough, and my guess is everyone on this webinar has probably spent many happy hours doing that, you begin to realize the word may has a lot of nuances to it. And I think that the takeaway for everyone is not to expunge may wherever it might appear, but to make sure you have a good reasoned basis for how you're using may in that context and can explain why it's not the Robare situation in your own disclosure. So, Cliff, very interesting case. It is, in terms of its consequences, still a work in progress, and time will tell. Thank you.
Great. Thanks very much, John. That was helpful. That was great. Thank you, John. And Ben, before we pivot to you to discuss the state regulatory initiatives over the last quarter, I just wanted, for those folks who are looking for CLE credit, our confirmation code is disclosure. So if you could please use the code disclosure for the sign-in sheet available for download from your viewing console. We'll be able to give CLE credit for that. So with that, Ben, could you walk us through the state developments?
Yeah, thanks, Cliff. So I'll be covering some of the recent state developments we've been tracking the last couple months. Beginning first with Massachusetts. So as Issa mentioned, the SEC adopted their own best interest standard and full rulemaking package on June 5th, and we have previously discussed other states jumping into this fiduciary debate as well on prior webcasts. We had even speculated, based on what we've been hearing, that many states had draft fiduciary legislation for broker-dealers and investment advisors operating in their state, but had been waiting to propose such legislation or rules until the SEC adopted their own rule. The basic idea was that these states were waiting to see what the final SEC rule package looked like. If the states were not satisfied with the new SEC standard and thought it should be higher, such as a true fiduciary standard instead of just a best interest standard, well, then those states would move forward and advance their own fiduciary rules. And that's precisely what Massachusetts did, because only 9 days after the SEC adopted their own best interest standard, the Massachusetts Securities Division proposed their own fiduciary conduct standard and circulated it for public comment. So under the Massachusetts rule, it would apply to broker-dealers, broker-dealer reps, which are agents in Massachusetts law, investment advisors, and also investment advisor reps subject to regulation in the state of Massachusetts. Some specifics we note here on the slide. It requires financial recommendations to be in the best interest of customers without regard to the interest of the broker-dealer investment advisor. This enhances the definition of best interest in Reg BI, which doesn't really say much other than that the firm must not place its own interest above the customer. It doesn't include the without regard to language that we see in Massachusetts' proposed rule. It also allows payment of transaction-based comp, provided that it's reasonable, that it's in that's the best of the reasonably available compensation options, and that the fiduciary duty of care is satisfied. And then also the fiduciary conduct standard would apply to recommendations, general investment advice, and to the selection of account types, such as the decision to open an IRA rollover account or the decision to open up an advisory fee-based account or a broker-dealer commission-based account. Just a couple final points on Massachusetts. First, the press release and statement by Secretary Galvin accompanying the rule were a pretty direct rebuke of the SEC's rulemaking efforts. Massachusetts clearly was not happy with the final rulemaking package. Second, the fiduciary duty is generally not an ongoing one if we're dealing with a one-off securities transaction or securities recommendation. If there is ongoing recommendations or any investment advice given, or if the ongoing compensation is received, if any ongoing compensation is received, then that fiduciary duty will be seen as ongoing. Third, the fiduciary duty includes both duties of care and loyalty, which are traditional fiduciary principles that would apply, as discussed, to investment advisors under federal law. And that care includes prudence, and that loyalty, for the loyalty distinction in Massachusetts rule, it says that disclosure is not enough and that you must clearly avoid conflicts of interest. So you can't just disclose away your conflicts, and that applies to both broker-dealers and investment advisors. The public comment period for this rule is currently open until July 26th of this year, and all comments will be made publicly available on Massachusetts' Securities Division website. As of today, I just checked, there's only been 2 public comments filed, but we suspect more to come soon. So in sum, there's some interesting similarities and distinctions with the New Jersey proposal, which was before it, and that's where we're headed now. New Jersey issued a proposal that was before the SEC's rule was adopted. So the New Jersey proposal was proposed on April 15th and requires investment professionals registered in New Jersey to place customer interests above their own when recommending securities or providing general investment advice. Note that the standard is initially similar to the SEC standard. It's just to not place the firm interests above the customers. But that's different from what Massachusetts did in proposing a standard requiring the firm to act without regard to the interests, without regard to their own interests. The comment period for the proposed rule in New Jersey was initially set to expire on June 14th, but that was just recently extended earlier this week. Just on Monday, they extended it to July 18th. So New Jersey will be holding a public hearing just one day before the comments are set to be due, so that they can kind of set the record, and discuss the proposed fiduciary rule. Similar to Massachusetts, the fiduciary standard will be wedged into the state's dishonest and unethical practices statute. Also similar to Massachusetts, the fiduciary duty in New Jersey includes both the duty of care and loyalty. The fiduciary standard, similar to Massachusetts, covers securities transactions, which include investment strategies, account opening decisions, and also transfer of assets from the accounts. New Jersey's rule also presumes that sales contests are an automatic breach of that duty of loyalty. It does allow for transaction-based comps, such as commissions, but similar to what we established in Massachusetts, they must be the best of the reasonably available fee options. So essentially, when determining whether to put a customer in a brokerage or advisory account and receiving transaction-based comp, it needs to be the best of reasonably available options. And then finally, also similar to Massachusetts, fully disclosing the conflict is not enough. There are certain conflicts that must be avoided entirely, as New Jersey stated. I guess moving on now to the final development here on the state side that we wanted to cover was the NASA Information Security Model Rule Package. So this was last month. NASA, which is the North American Securities Administrators Association, and they generally advocate on behalf of state securities regulators, and from time to time will issue these model rules that many states choose to adopt in substantially similar form. NASA recently, last month, adopted a proposed information security model rule package for investment advisors only. It did not apply to broker-dealers. This has been a hot topic issue for state securities regulators, both the protection of non-public personal information, protection against malware or cyber attacks designed to obtain this non-public information, and also the protection of actual customer assets and securities that are custodied directly with the advisor. So not surprising that given the state activity in this space that NASA issued a model rule. Note that the model rule was first proposed for public comment back in September 2018, but they're only now adopting it. So really quickly, three main components to it. First, it requires advisors to adopt policies and procedures regarding information security and must deliver this privacy policy annually to clients. The advisor must also review and amend their policy as needed, but no less frequently than annually. So this now must be an ongoing duty for investment advisors to kind of review their information security policies. Second, the model rule amends existing model record-keeping rules to require the advisor must maintain the records related to the information security policies. So this would include records related to the creation of the policy and also any records related to, for instance, the amending the policy or reviewing it on that annual basis that we mentioned earlier. And then third and finally, the model rule amends the model unethical practices state securities laws to include the failure to maintain these required information security policies as yet another example of an unethical business practice or prohibited conduct. NASA does get into the specifics for a little bit. If we could move to just the next slide, the specifics of what should be in the policies and procedures. So the policies must cover the following 5 areas: identification, protection, detection, responding, and recovering. And really what you see here is kind of the full life cycle that the state securities regulators really want to instill into firms regarding how to kind of protect and handle a cyber attack or breach. So with that, I'll kind of pause there and turn it back over to Cliff.
Great. Thanks, Ben, for walking us through that. So we go from the states back to the SEC, and in particular the Division of Investment Management, which issued a very important no-action letter to the Money Management Institute, MMI, dealing with mutual fund prospectus delivery in the context of advisory programs. No, I'm sorry. Yeah, Michael's pointing out the ball bounces not to the Division of Investment Management within the SEC, but the Division of Corporation Finance. Yeah, thanks, Michael. And yeah, so Michael's going to walk us through that.
Sure. Thanks, Cliff. So this is something that, with everything else going on that we've talked about, probably snuck under the radar for a lot of people. It deals with a source of agitation that for both broker-dealers and investment advisors for many years. When you have an advisor that's managing a client's account on a discretionary basis, such that the client doesn't really find out what is being purchased for their account until after the fact. You have broker-dealers who are executing these purchases of, let's say, mutual funds for these clients of the investment advisors, sending prospectuses to these clients. The question has been raised for some time: what's the value of that? To what end? What's the purpose? The advisor has discretion, is making all the investment decisions. What's the point of sending something to the client who's granted discretion to the advisor to make their investment decisions? There's no point. It has really been the thought for many years. So the MMI basically said, enough of this, we got to go to the SEC, go to Corp Fin, and the reason why for Corp Fin is because the request relates to prospectus delivery, which is something that is controlled by the Division of Corporation Finance, Section 5B here, in particular 5B2 of the 33 Act, contains a prospectus delivery obligation. And the MMI said to the staff, hey, if the broker-dealer knows that the client of the advisor has granted discretionary authority to the advisor and has also authorized the advisor to receive prospectuses on behalf of the client, can we just send the prospectuses to the advisor, which is the one making the investment decisions, and not send all these prospectuses to the clients as well, because it serves no purpose, although they didn't say that in the request, but that's the real reason. It also is costly and a pain in the neck, again, there's no point. And the staff said, fine. If you, the broker-dealer, know that the client is represented by an advisor that's managing their assets on a discretionary basis, and also the client has authorized the advisor to receive the prospectuses as agent of the client being the principal, the advisor being the agent, then that's fine if the prospectus is sent just to the advisor. The request by the MMI basically talks about a lot about the restatement of agency, that agents can basically, it's common under agency law, has been for decades, that notice can be given to an agent acting on behalf of a principal if the agent is acting within the scope of their agency. And they said, well, why should it be different here? The staff granted the relief, and there we go. So no longer will broker-dealers have to send prospectuses to all of the clients of an advisor that's managing their assets on a discretionary basis, as long as they know that and that the advisor is authorized to receive the prospectuses. So it should save a lot of money for the broker-dealers and hassle from for both broker-dealers and advisors from the clients who are getting all these prospectuses that really serve no value and things that they don't really want to receive. So that's good news.
And a corollary to the no action relief that was issued to Goldman Sachs maybe 3 years ago.
Yeah, about that.
Yeah, that dealt with the delivery of ADV, the ADVs.
Right. In a private fund context.
I think it was in the sub-advisor.
Yeah, sub-advisor, yeah.
Sub-advisor
Yep.
context.
No, sub-advisor context. With that, Bria, we go to you to take us through the OCIE updates.
Thank you, Cliff. To our audience, good afternoon, and thank you for joining us. Today, I'm reviewing 3 updates from OCIE. The first update from OCIE relates to its risk alert on firms' use of cloud-based storage. On May 23rd, OCIE issued a risk alert explaining security risks associated with the storage of electronic customer records and information by broker-dealers and investment advisors in various network storage solutions, including those leveraging cloud-based storage. Particularly, OCIE has observed that firms that have either misconfigured network storage solutions, provided inadequate oversight of vendor-provided network storage solutions, or firms that have insufficient data classification policies and procedures. They identified a number of issues under each of these areas that firms should seek to address. They outlined a few best practices, including implementing configuration management programs that include policies and procedures governing data classification, vendor oversight, and security features. And we can go to the next slide. Including policies and procedures designed to support the initial installation, ongoing maintenance, and periodic review of the network storage solution. Guidelines for security controls and baseline security configuration standards to ensure proper configuration of the network storage solution, and policies and procedures for vendor management that include implementation of software patches and hardware updates, followed by reviews to ensure that patches and updates do not unintentionally alter the security configurations. We can go to the next slide. So the second update from OCIE relates to statements made by OCIE's Director Peter Driscoll at the SIFMA Operations Conference last month. Director Driscoll highlighted similar observations around the use of cloud-based storage. Particularly, he noted that OCIE has observed some of those same observations, firms' policies and procedures not covering standard security features, such as encryption or password protection or other available tools to limit access to information. Firms' policies and procedures did not address configurations to the security settings on storage solutions to protect against unauthorized access, or their policies and procedures did not sufficiently address requirements for implementing secure configurations, especially with respect to cloud storage. And lastly, firms didn't adequately oversee vendors to ensure effective implementation of network storage solutions. Director Driscoll suggested that firms adopt the following best practices, some of which were also included in their risk alert that came later in that month. In particular, updating policies and procedures to keep pace with evolving risks and technology, including comprehensive vendor management in the firm's cybersecurity strategy, ensuring the proper security configuration management of network and cloud storage, establishing policies and procedures to secure hardware, for example, mobile devices and servers and laptops and hard drives. And then finally, something that wasn't included in the risk alert, assessing policies and procedures for inventorying and deactivating and removing hardware once it's removed from service, especially for any data that's required to be retained by SEC rules. So securing hardware and making sure that you're not losing any data that you should be retaining that is located on that hardware. And we can go to the next slide for the last update. So the third update from OC relates to statements made by Director Driscoll at the NRS Spring Conference in April. Director Driscoll highlighted several observations that OC examinations will or have focused on, and particularly OC exams will include a review of disclosures relating to conflicts, fees, and expenses, which we are familiar with. He did note in his speech, however, that there are still share class selection issues being identified in examinations, and those are going to continue to appear. As we're most familiar with custody rule issues, internal controls around handling and processing of investor funds and assets, the review of borrowing arrangements, and review of firms' compliance cultures. And Director Driscoll also noted that OC is launching a pilot initiative for regional roundtables in select cities with CCOs to better the SEC-CCO relationship. Lastly, Director Driscoll provided insight into prior examinations. He noted that there have been reviews of 200 advisors with a significant senior client base, and those reviews focused on firms' awareness of state and federal laws addressing senior financial abuse and exploitation. Those are our updates, and I'll hand it back to Cliff.
Great. Thanks, Bria. We appreciate that. Thanks for that OC update. And we have a couple of minutes just to take a couple of questions. One question that came in had to do with the applicability of Massachusetts and New Jersey with respect to advice or selling activity with respect to insurance products. I'll take that. I'll give a 30-second response, and then Ben, maybe I can hand it to you to take a question that was asked about the federal preemption of these state initiatives. With respect to insurance products, the framework for thinking about whether these state laws are applicable to activity related to insurance products is whether the state law, not the federal law, whether the state law, its definition of securities includes insurance products. New Jersey's doesn't. And as far as we know, Massachusetts doesn't. So on its face, the regulations don't apply to activities with respect to insurance products. One thing though we're thinking through is in Massachusetts they've been pretty aggressive and they've taken actions against broker-dealers in terms of their sales activities with respect to variable products, and we want to sort of figure that out in terms of what that means versus, in terms of their aggressive stance from an enforcement perspective with respect to what their statutes say about insurance products not being included with security. So, again, New Jersey, we seem to be a bit more comfortable saying it doesn't apply. Massachusetts, we want to get a better sense. But, again, the framework is, the starting point is, does the state definition of security include insurance products or not? Hey, Ben, why don't you, we did get a couple of questions about preemption. Could you just lay out the framework there?
Yeah, sure. I'll really quickly do it. I mean, on the question of whether the SEC said anything about whether they would view their rule as preempting state fiduciary rules, the answer there is no. They didn't really say anything direct on the point other than punt to the federal courts, where I imagine this will be most likely litigated under the National Securities Market Improvement Act of 1996, which carves out certain areas of regulation for broker-dealers and investment advisors that cannot be regulated by the states if they impose a different standard than what the federal standard already applies. For instance, one of those areas would be record keeping, and as the argument would go, that these state rules create different record keeping obligations on broker dealers and investment advisors. Different record keeping obligations than what the SEC imposes, at least, and so I imagine these arguments will be litigated in the future, and we'll be curious to see how it comes out. But the SEC didn't say one way or the other whether they would view their rule as preempted by state law.
Yeah, and in fact, they sort of gave a nod to they understand that litigation, just as you're saying, may come about. Yeah, thanks, Ben. That's helpful. Hey, we'll wrap up, but before we do, just one question that I'll hand over to Issa. Does as part of the rule package, the SEC required a new Form CRS, which is a relationship summary document. Does that apply? Would that apply to advisors?
It would. So for investment advisors, they are now, being required to hand out something called a Form ADV Part 3, as if Part 1 and Part 2 were not enough. And the Part 3 is basically the Form CRS. There's a particular, set of questions or topics that an investment advisor has to address as part of its Form ADV Part 3 or its, Form CRS, Customer Relationship Summary. But that there is an obligation under that CRS rulemaking for investment advisors. It is another separate piece of paper that has to be handed out, and it's supposed to kind of lay out the kind of same general concepts that you'll see on the broker-dealer version in terms of the terms and the scope of the relationship. It's also going to be something that's required of dual registrants. Dual registrants have an obligation to hand out a CRS. You might recall that under the proposal there was a separate mock-up that was provided for dual registrants, and a separate list of questions that dual registrants in particular would have to question, a separate prompt of set of questions that dual registrants would have to answer. As part of the adopting release, the SEC eliminated the dual registrant version of CRS, so to speak, and now they're down to two versions: an investment advisor version and a broker-dealer version. And if you're a dual registrant, you have to either hand out, basically whichever one applies to the relationship that you're discussing with somebody, or if you wish, you can prepare one that covers both types of services. It's just up to you whether you want to do one that covers your broker-dealer services, one that covers your advisory services, or one that covers it all. But there is some guidance in there about how dual registrants are supposed to handle the CRS obligation as well.
So it definitely does apply. Yep.
Yeah, that was a long-winded way of saying yes, it applies to investment advisors.
And in fact, that's going to be a big deal. It is going to be a big issue. So thanks for taking that.
Yep.
And thanks everyone for joining us again. We want to thank everyone. And as a reminder, if you'd like to receive CLE credit for the webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And please feel free to contact any one of us with questions. Also, requests for the deck. We'd be happy to send it to you. So thanks again, and we'll be back next quarter. Take care.
Thanks, everybody.
Thank you.